Welcome to the second workshop of our six-part Get It Done webinar series on estate planning. And I sure hope that you love that music piece by Peter Allen as much as I do. I think it's fabulous. Hope you do too. I'm John Mitchell, CEO of Ardenwood here in San Francisco. And joining me is Rick Bailey, one of the most respected estate planners in the country. Thank you again for being here. We've received some very positive feedback, and we're grateful to those returning after our September session, and we welcome those who are here for the first time. Before this session, you should have received two handouts via email today. Hope you have those with you. Once again, this series is designed to help us move forward together to finish this important project. Rick has helped countless Christian Scientists at every stage and income level navigate estate planning with clarity and care. We're grateful for his support in these hands-on sessions. Rick will start by sharing a few insights, and then we will answer your questions and offer guidance. The goal is that by the end of this series, you'll be ready to meet with your lawyer and finalize your plan. Once again, to protect your anonymity, please use the Q&A icon at the bottom of your Zoom screen to ask your questions. I'll read each one aloud without mentioning your name so that everyone can benefit from Rick's response. And with that, let's get started, Rick.
Appreciate being here. I know we're separated a little bit. I'm in Arizona today instead of California. Glad you let me come and visit you last month, and being at Ardenwood was great to see, and it's a peaceful place for anybody that hasn't been there. So, all right. So, do we want to start with any questions today? Do we have any follow-ups from last month, and we can start there?
I do have one question that has been asked. The questioner asks, what if I don't have investment accounts or own a home? Do I still need a trust or a will? Would you please talk that through a bit?
I think that's the key to beginning the estate planning process. So with estate planning, I think the overwhelming view out there is that it's just a plug and play. Just like everything in today's world, it's Amazon. You get on, you order something, it shows up. Hopefully today. I know I get upset when it doesn't come today and it doesn't come till tomorrow. But estate planning is not like that. Estate planning needs to be very specific to you and your situation. So whether you have real estate, whether you have a business, whether you have investment accounts, or whether you don't have those, it's your planning begins with you. And that's why last month I wanted to make sure we started with inventory what you have. Start with what you have so that when your estate planning is being built, you might not need a trust. You might, be able to accomplish all that you need to have with a will. So if you don't have investment accounts, well, let me back up. And we talked a little bit about this last month. For some assets, and I look at asset categories. So if I'm looking at assets like investment accounts, bank accounts, those types of accounts, you can go to your bank or you can go to your investment company and actually sign a document so that when you pass, all of those are going to go based on the beneficiary designation, the form you put on file with those companies. So does your bank account need to be in the trust? The answer is no. Now hold on a minute and I'll come back and say why you might want it in the trust. But the answer is if you don't have that investment account, okay, we don't have to worry about that asset. We have to worry about your other assets. With your bank account, you can have a beneficiary designation. With your retirement accounts, you can have a beneficiary designation. If you have real estate and assets like that, well, obviously you can't have a beneficiary designation on your real estate. There'd be nowhere to put that. So those assets, by default, we need to move them into a trust. If you don't have them in a trust at your passing, then we end up in probate, which means go to court. the delay and all that, there again, depending on the state you're in, is going to dictate how onerous that process is and how expensive that process is. If you're in a state like California, New York, some of those states, being in probate is just brutal. It's expensive, it's time consuming, it's beyond frustrating. So when we talk about the assets and when we're talking about each type of estate planning document, you may need all of those documents, you may need some of those documents. And to be specific, we just want to make sure we're working through the process and taking it a step at a time. So when you're ready to go and have your estate plan put together, you're doing it in a way that matters to you. And I've had people come and ask me, what is the perfect estate plan? Well, I can tell you my perfect estate plan because I've put mine together. But there again, if you look exactly like me, have the same goals and objectives as me, that's the perfect plan. It's perfect for me. It probably is not perfect for anybody else unless it just was by accident. So we want to make sure all of this planning is personal. It's set up to match your goals and objectives and based on what assets you own. Let's don't create something we don't need. So I have met with clients that, you know, I would say for the amount of their net worth, they would be told by 10 out of 10 attorneys to get a trust. When I reviewed what they had, they didn't need a trust. They could do it all with a will and accomplish it all because it was the way the accounts and assets were held, not just the dollar value. So if anything you hear today is planning is personal to you and needs to be personal to you. So does that answer
That's
that question, John?
that answers the question. That's the only question we have so far for today.
Okay.
So why don't we continue on with the handouts that you got out and we sent out and get started.
Okay. So the first handout that you would have gotten today is a recap of the different estate planning documents, the basic estate planning documents. You'll hear me either say basic estate planning documents or the foundational documents. These are documents that most everybody will need. So you and one of them's the revocable living trust. There again, to avoid probate, if you're in a probate situation, we need to make sure we use a revocable living trust. What that's going to do, in essence, is replace the will. We hope it replaces the will. It's going to tell us where all of your assets go when you pass. But it will also do another thing. If you lose mental capacity, and we don't ever like talking about this isn't the fun part of talking. If you lose mental capacity, who is going to take over for you? And if you don't have your assets in a revocable trust and you have people set up to take, as successor trustees to take over for you, well, I can tell you, because I've been through these hearings, we end up in a guardian and conservatorship hearing. So it's a court case paid by your checkbook to hire your attorney, the court's attorney, and everybody's there to determine whether you have the mental capacity to manage your own affairs. And those are very emotional hearings. Nobody likes them, but we need that because if you can't manage your affairs, who's going to do it for you? And just remember, now if you didn't designate who that person is, guess what? Now the court's going to designate that person. And is that who you wanted? That question is irrelevant at that point because the court gets to decide. So it could be, whoever the court deems necessary in that position, and they get paid for that job. And so we don't want to do that. So that's part of the revocable living trust, is to have that person in place if you lose mental capacity. The other documents that you'll see on the sheet are a durable power of attorney. Those are to handle any documents or any assets that have been left out of the trust We will always leave your qualified plans, IRAs, those types of assets outside of the trust. So we always need that durable power of attorney, even if we've done all the planning. That's just there to handle those assets. A healthcare power of attorney. There again, who's going to make medical decisions for you? Who's going to make sure your health care is being taken care of the way you want it to be? And specifically based on your desires. There again, if you don't have a healthcare power of attorney, the courts step in, they name the person they deem qualified to take care of you and make all those decisions, which may not be based on your beliefs or desires. The last one and is the a living is a will. There again, if you have a trust, that will is I just say it's there for whoops. Whoops, we forgot something or missed an asset. Take that asset, put it in the trust, manage everything from the trust. If you didn't need a trust, then that's going to dictate how everything gets distributed, who your beneficiaries are, your heirs, and how, what, and where you want it to go. There again, oh, if you have a will, we're going to be in probate. There again, if we know we're going to go into probate because of the types of assets, and we know that's going to be a minor um, inconvenience, that's okay. We've made that decision and we've made it proactively. There again, those are the documents that we would cover in the foundational estate plan. Now, let's shift gears a little bit because here's more of what I want to talk about today is who is going to be in control. And when we talk about estate planning, we know during your lifetime, while you have the mental capacity, we want you to be in control of your affairs. We want to make sure that you know what assets you have, how best to manage them, and set them up. Now, that's completely outside of today of what we want to talk about is how you're going to manage your affairs while you're alive. I mean, that's completely different conversation. Now let's talk about at the point in time whether you pass away or you lose mental capacity. What you'll hear is the word fiduciary. And I hear that word thrown around. I hear it thrown around from investment companies in ads and everything else. Here's what we mean by fiduciaries. These are the people that you trust to take over when you're not either able to do it or you're no longer here to do the job. So let's go through them one at a time. So if you have a trust, when you set up the trust, there's going to be really three positions that we have to worry about. Number one is the grantor. The grantor is you. You're the person setting up the trust. So the grantor's job is to set up the trust, have the trust designed the way you want to have it designed. All of the rules, regulations, everything inside that trust are based on your desires. Your other job as a grantor is transfer assets into the trust. Now, when we talk about a revocable living trust, since the assets are going to be controlled by you in two positions, it's being a grantor and being the trustee are almost one and the same, but you have to understand which role you're in. So grantor, setting up the trust, transferring assets into the trust. Once we have the trust set up, the two things that we're going to worry about are the trustees and the beneficiaries. Today, we're not going to get into much of the discussion on beneficiaries. I want to talk about the trustees. During your lifetime, you are going to be the trustee of the trust, which means you've got sole and absolute control of what happens in this trust. If you think about it, you're driving the ship here. So it's one where you have to look at the document. What does the document say that you can do? Now, as a revocable living trust, if you don't like the terms of the trust, we can always change them. But it's the grantor that changes the trust, not the trustee. The trustee is the one that's actually doing the work of running the trust. Now, while you're alive, just remember If you're have a revocable living trust, you have sole and absolute control of everything you're doing. Now, you lose mental capacity or you pass away. Now you have to have who's going to take that next role? Who's going to be the successor trustee? I think a lot of people when I am working on the estate plan, they don't think about two very distinct roles there. They get caught up thinking when I pass away, who's going to be the trustee to manage things for my kids, my grandkids, whoever, who's going to take those assets, make sure they're organized, make sure they're accounted for, and distribute them based on how the trust tells me to distribute them. And I think that's the easier role to envision because most people think I'm here, I'm healthy, and then I pass away. Now it goes to my heirs just like I want it to. Let's have the uncomfortable conversation. And the uncomfortable conversation is the role this trustee is going to play to take care of you. You're still alive, but you don't have the mental capacity to manage your own affairs. So what we want to do is we want to have a mechanism in this trust, number one, that is easy for us, for either you to say, raising your hand and saying, I voluntarily give up control of my assets because either I'm tired of doing it or I feel like my mental capacity is starting to go to where I can't run run this the way it should be. Or we have whatever mechanism you want to put in place that says, here's two people, or here's somebody that gets to determine whether I don't have that mental capacity to go forward with my affairs. Now, that's the rules of how that operates. We want to make sure that's in there and you agree to it, that it's what you want it to be. Now, think about the role that this person's going to play. They're going to make sure they're managing these assets to take care of you the way you would want to be taken care of. Now, think about what I just said. The way that you want to be taken care of. Guess when most people find out they're the trustee on somebody's trust? It's after the fact, something's happened, and nobody even told them they were the trustee. Well, how can they be the trustee and take care of you the way that you want to be taken care of if you haven't talked to them, or if you haven't given them more direction on how that should occur? So I want you to think about, number one, who's the right person, and how are you going to communicate the role to them? That can be, a lot of times I'll say, put a letter along with your trust, update that letter every year that says, this is what I'm doing and why. And I would add into there, this is how, if I lose mental capacity, here's how I want to be taken care of. And give them direction. Be honest with them. This is what matters to you. And it can be, what matters to you is different than what matters to me and what matters to John. We don't count, you do. So we want the right person in there. And I see this with parents that have, multiple kids. They always think the oldest one gets the job. Well, that's okay if the oldest one should get the job. Put the people in place that should be in those fiduciary roles. It's not a popularity contest, and it's not age-based. Now, let's move through the other ones. The same person that you put in as a trustee probably is the same person that you're going to put in the role as executor of the will. So the executor of the will, their job, if you pass away, is going to be find all of your assets. Well, let me step back. Their job first is go file with the court to get permission to act as the executor. So they need to know where your will is. They need to be able to take that in, submit it to the court, and now they can act as the executor of your estate. Their job is to inventory the assets, notify the heirs. Now, here's the other thing that happens in a probate. They have to notify all of your creditors that may have a claim against your estate. If you want, come make the claim. If they know of a creditor and leave them off, now they're liable. So it's one I see that they will, if they know of anybody that you might owe money to, here's the place to come collect. And so that notice goes out. Now, once everything's done, then they distribute whatever's left according to your will. But the same kind of mentality that you would have as a trustee is probably the same mentality that you would pick for the executor. There again, not a glamour position, not a fun role to be playing, but it's a necessary role that we have to have the right person in there. So pick the person or persons, and you can name these people. You can say first, if I can't do it, here's who's going to be in first place successor, here's second, and sometimes 3, 4, and 5 if you want to list them that far. Now, let's jump over to the next document, the durable power of attorney. Now, I'm using that word durable for a very, very specific reason. Under a power of attorney, you're going to give somebody, so let's say I'm making John my agent under my durable power of attorney. When I set up a power of attorney, this is under agency law. Agency law says I can give somebody power to act for me. So in this capacity, I'm going to say, John, I need you to act for me. I'm giving you all the power under this power of attorney, and I can make it very specific and say, I need you to go finish and buy this real estate and finish the transaction for me. And so John can go and sign all those documents for me. John acts as if he is Rick. And that's agency law. Now, here's the problem. Under agency law, it says you can only act if the principal under that has the ability to act. So if I have legal capacity, mental capacity, John as my agent has that legal mental capacity. If I lose mental capacity, John no longer can act for me because I don't have the ability to do it, therefore he can't. So we have to add this word, a durable power of attorney. That means as long as I'm breathing, John can act for me as my agent under that power of attorney and do everything possible according to the rules of what I've laid out. So there again, I can be very specific. I can be very broad in what I say, or I can limit it. I will say one thing that I add into a lot of the powers of attorney that I do. I make sure if somebody's been making charitable contributions, I can see they're making annual contributions. I will add that in there. They can continue making charitable contributions just like the principal was doing. So therefore, if I'm not able to do it, John, I want you to do that for me in my place. Now, when you pass away, that power of attorney now is void. It only lasts up to the date of death. Now, let's jump to the next document. And I think this is, in the situations I've dealt with, I would say this is important, if not more important as any of the other documents, and that is a healthcare power of attorney. And there again, the healthcare power of attorney is very specific in if you can't make medical decisions, healthcare decisions, who's going to do it for you? Who's going to step in and take care of you the way that you want to be taken care of? Now think about how important that is. You know, do you want extraordinary life-saving measures made? Do you want to be taken care of the way you've lived your life? All of those decisions there again, if you can't make them, it's either A, nobody's making them for you, but in reality, the court now steps in and makes those decisions for you. And if the court's making those healthcare decisions, the judge is the ultimate decider of what happens. And you can see, news stories after news stories of people that were not taken care of the way they wanted to, but a judge ruled that that's the way it's going to be. So these fiduciary roles are very, very important. I was just on a call earlier this week, and it was one with a gentleman. He's single, he's divorced, and his existing documents all have his ex-wife as the one taking care of him. And that's been that way now for the last 10 years. And I jokingly asked him, I said, do you think your ex-wife's going to take care of you the way that you want to be? And he laughed and he said, no. And I said, well, we probably better get this fixed. And there again, it's make sure it's set up, that you're getting the right people in place, and then that you update that as you go along. A lot of people look at this, they put their estate planning documents and they get them done right, and they think this is a one and done process. They take that, they get it signed. I don't want to ever see another attorney the rest of my life. I get that. I don't want to go through this process because it's difficult. It can be heart-wrenching. It can be frustrating. So what do? They take those documents, they throw them in the drawer, and they hope they don't ever see them again. And the problem is, once something does happen in mental capacity, passing away, those events occur. Now we have to go blow the dust off, and I've looked at those documents, and everybody in the room looks at those documents and say, this is not what they would want. But guess what we're bound to? We have to do exactly what those documents say. So part of this process, and it's an estate planning process, once you start the journey, you can't stop. And part of this journey is get the documents set up the right way today. Some of this you're going to be making decisions that you may not be ready to make today. But I will tell you, make the best decision you can today with the best information available to you today. Now, things change. Things will change in how you want to distribute things to your kids. They'll change with the charities that you're including in your distributions. They'll change with the people that you may want to include as beneficiaries for whatever reason. All of those things change. Then you start thinking about those people that you just made as the fiduciaries, the trustees, the agents under your power of attorney, the executors of your will. All of a sudden, those people change. And you start looking at it, these might not be the people I want taking care of me or taking care of my kids or my estate. All of those issues start coming up. And what I'll tell you is, updating a will or trust is simple. As long as it hasn't been, if it's been 10, 20 years, we're probably throwing it out and starting over. So you're going to go through the exact same process, very similar cost to what you had the first time, just to get back to where it needs to be today. If you do the annual updates, and what I like to do is I will tell my clients at least once a year, pull those documents off the shelf, blow the dust off of them, and just think about, who did you put in those positions? Has anything changed with who you want to include as beneficiaries of your trust or your will? Is there anything in your life that has occurred that may cause you to need to make some adjustments here? any of those things happen, the adjustments in the trust, the will, the powers of attorney, they're simple. I mean, it's one where all we have to do in a trust is say, you know, take out section 3.1 and replace it with this new language. Done. Get it signed, notarized, put it along with the trust. That's done. It's easy. If it's a will, the only thing I have to tell you is we need two people to witness it plus a notary to make sure it's valid in every state. There again, it's a little bit of a hassle, but it gets it done the right way. So everything's up to date for you on a regular basis. Yeah.
Got some good questions here. Rick, that is so helpful. This, your wise counsel is very much appreciated. First question. What is a living trust? Is it different from any of the other trusts?
Yes. Here's with a living trust, you're going to have it, you're going to hear it said as a living trust, a revocable trust, or a revocable living trust. They all mean the same thing. Now, what happens in a revocable living trust, that is, I like to tell everybody that's the will substitute. And we're setting that up now. We're putting the assets in there and we're going to manage the assets inside the trust going forward. What I like about this, remember the word revocable. If it's revocable, you can change it anytime you want as long as you've got mental capacity. Now, let me put a little caveat in here. If you're in a state where if you're married and you're doing a joint trust, you will have to make a decision. Is this going to be amendable and revocable no matter as long as one of the spouses is living and capable? Or does half of the trust become irrevocable at the first passing, the rest becomes irrevocable at the second passing? So that's what you just have to decide if you've got a joint trust. I would say most spouses in most states will do a joint trust, not separate trust. Now, let me tell you the opposite of a revocable living trust. We will do some in estate planning with irrevocable trust. The reason we will use irrevocable trust is we'll use them for asset protection purposes. If we're in situations where we want assets, protected away from creditors currently, we'll use them in estate planning for estate tax purposes, and sometimes more for beneficiary control. We have kids that are a little bit wayward or whatever, then we'll bring in some of those irrevocable trusts. The one thing I remind everybody, if we're doing an irrevocable trust, that is completely and totally separate from your revocable living trust. Those are two completely separate documents. They have two completely separate and different purposes. The other thing that I remind people, if we go to an irrevocable trust, remember that word irrevocable. Irrevocable means you cannot change it. Now, I will put in flexibility to maybe make some changes on the backside, but irrevocable means we've painted ourselves into the corner. And I've dealt with people that have done irrevocable trusts, did not understand them, and they are not happy to this day because there's nothing we can do. So just remember, revocable trust, living trust, revocable living trust all mean the same thing. That's part of your foundational trust planning documents.
Perfect. What document, Rick, do I create to write down my wishes related to my health, where I want to be cared for, and what I want to happen when I pass?
Depending on, I'd like to include that in the health directive, but I would include some of that in your trust and will, so that it's in. I overkill on this is not a bad thing as long as you remember that you've put it in there. But it's one, if you want to be buried it in a very specific place, manner, whatever. I like putting that in there. I also would see if the part of that includes healthcare, especially end of life healthcare. I like to have that's very specific in the healthcare power of attorney, where you'll also hear that as a health directive. And so that's a great place to put that language in there. And there again, everybody has specific things that matter to them. We just need to make sure we get it included.
Perfect. So important. So very important. Next up, there are professional guardianship agencies who are often hired by the court who will impersonally and carefully oversee and manage your person and estate appointed by the court, not hired by the court. Your estate is the payee. Not sure if that's a little confusing.
Yeah, that's so here's what's going to happen there is if you're getting to a professional guardian or conservator, because you can have both, and there's different roles. So if you think about it, a guardian, professional guardian is taking care of the person. A professional conservator is taking care of the assets and the money. So what can happen is let's kind of play out the scenario that I see this in more times than not. We have an individual, and a lot of times I'll see this that they are single or their spouse has passed on, and they didn't they didn't have a will or a trust in place that said here's how things should happen, and they lose mental capacity. And typically that can be a guardian and conservatorship hearing can either be voluntary or it can be involuntary. So if you have somebody that thinks you're acting erratically, they can actually file for the guardian and conservatorship hearing. So what'll happen there again, if we have your things set up in a trust, now somebody steps in. We've already taken care of somebody making sure you're taken care of either under the healthcare power of attorney, durable power of attorney, that's taking care of your property and you, and the assets that we put in the trust, they're being taken care of by the successor trustee. We've got you taken care of. Now, it's one where if you end up going to a guardian and conservatorship hearing, the judge he's going to listen to the medical professionals about your mental state. He's going to listen to them about your ability to take care of yourself. He's going to listen to them about your ability to take care of your assets. Now, if you haven't set out who's going to be taking care of you, now the court gets to appoint somebody to take care of you and take care of your assets. There again, the wording was correct. Court appointed, but paid by you. So that gets paid out of your assets, not paid by the court. The court oversees that. So I have in the past, I have been a court appointed guardian and conservator for a minor. It was a situation where his parents were not allowed to take care of him and take care of his money. And so I was asked to be appointed in that position. I knew the family. I was willing to take on that role for the benefit of the child. And I had to file documents with the court on a regular basis of what was being done. So, you know, there again, I'm a professional being paid, but I'm being paid by the family and by basically the assets of this child that in a better situation would have been taken care of by somebody that should have been in that spot. So if you have people that you want in those positions, we want to set up those documents so you don't end up paying just for the lack of preparation.
Absolutely. So important. Next up, how should a couple label their accounts? Partnership, rights of survivorship, etc.
It will somewhat depend on the state, but it's one where most of the time with spouses, it's going to be either, if you're a community property state, you can name it as community property. In a separate property state, it would be, you can do it joint with right of survivorship. And there again, we've got to be careful, because if it's bank accounts, you can have the bank account, like it's one of my bank accounts says Rick and Kim Bailey. It's joint account, right of survivorship. And we're in a community property state, so it's community property anyway. And as either of us can sign on that without restriction. If one of us passes, the other one gets it. Now, we want to be careful here. Accounts we can set up easily to move from one spouse. So if you're in a separate property state, let's say you're in the state of Oregon. Oregon is a separate property state. I could, if I was in there, if I could have an account and it would say Rick's checking account on there, I can put a transfer on death. So if something happens to me, it goes to my wife. Kim can have a separate checking account that does the exact opposite. So we know everything flows back to each other no matter what. Now let's move to real estate. This is the one that I think is the more concerning. And I just came across this with a mother and daughter. They had the property set up. Mom had set up on the deed. We are joint tenants with rights of survivorship. And they thought, well, this is great. If mom passes, daughter automatically gets the property. Daughter is entitled to the property. But guess how we get the title to the daughter? We have to go through probate. So just because you have the right to it doesn't mean you get to control it. So in that case, this one was in California. The daughter would have had to go through probate, pay the probate fees, pay the attorneys, all of that, wait, quite some time to get the property she was already entitled to. Because if you have two people that buy the property, we need two signatures after to move the property. So be careful here when you look at it. I either like it for spouses, community property, joint property, but make sure that it transfers depending on the type of asset that it is.
Perfect. Next up, is the court that must be notified in the county where the decedent lived or the county the trustee executor lives?
It is the county where the decedent lived. So this is one you got to follow it through a little bit more. So it's there again, the trustee, when you're picking the trustee, think about convenience factor too. So I've had one, this was years ago, a business partner of mine. He was living in Oregon at the time. He was named as the executor of a will in Southern California. So he said, yes, I'll do this, took it on after the fact. And one, he didn't know he was appointed until after the person had passed. And so he would have to fly from Oregon down to California to handle all of those transactions.
Hmm.
And luckily it was a friend, so he wasn't charging them. But there again, if he was in a situation where he's missing work, having all those extra bills, guess who's paying for that? So the probate is filed in the state and the county where the deceased lived. Now, the other thing be careful of is where if they have property out of state, now we have to have a secondary probate, an ancillary probate in that other state where those properties are located. So I've had clients that have died in California, and they had property in New York, so they had to probate in California and had to do a secondary ancillary probate in New York where the property was located. So they had the worst of every circumstance. So just make sure we know where the properties are. And this is where you come back in when you're picking the fiduciaries. Think through what you're asking them to do. So if you've got a trustee, okay, a trustee can manage property. I can manage property on the other side of the world. I can manage bank accounts on the other side of the world. I can get real estate property managers to help out whatever I need. So some of those, managing the assets usually is not the problem. Start thinking about managing the people. So if it's one where you've asked me to be your healthcare power of attorney, I'm now the agent managing your healthcare decisions. And I've had some that have appointed their kids that live 2,000 miles away. How are they going to manage your healthcare from 2,000 miles away? They can't go to appointments with you. They can't go see your healthcare professionals with you. They're not there on a regular basis. So yes, you might want your daughter to be your healthcare power of attorney. But if she's 2,000 miles away, you may want to rethink who should be in that role.
Really thinking through all these things, isn't it? That's why we're having this.
Yep.
Next question. How would a successor trustee or executor get compensated for the work they would be doing?
I've seen it done two ways. And the first way, and typically what I see is, pay them a reasonable fee. And that's typically what the document says. And if it's a family member, most of the time they just want to recoup their expenses. Maybe if they've taken time away from work, recoup that lost money. If they're looking for how a professional does it, a professional trustee will take a percentage of the assets being managed, 1, 2, 3%. And so that I typically say that's our range. Anything from reimburse them to probably 2% of the assets being managed. I typically, since they're asking, somebody that is closer to the family, that's why I say most of the time it's going to be just recoup and pay a reasonable compensation. But remember, this is a time consuming effort. And
A lot of work.
I mean, I see the amount of effort that goes in, and it's a thankless job. No matter what you do, somebody's probably upset at you. But it's one where if you know that it's going to be a more complicated transaction, you can put a dollar amount in there. Pay them X dollars for their, to do this job from the estate. So there is no set rule of what should be there. I just say at least be fair to them. Don't just say, hey, it's your responsibility as the oldest child to do it. No, it's one, it takes work and effort, at least put in there and give them reasonable compensation.
Perfect. Absolutely. Next question. To make changes in beneficiaries in a revocable trust, does it have to go through an attorney or can it just be revised by the person whose trust it is and then notarized?
If you get the correct language in there, you can do it yourself. And so I'll tell you the language. So let's say, I'll use it as my trust. I have a trust and it's, I've set it up. It's the Rick Bailey Revocable Trust. And it will, just so you know, with every trust, it's very specific. It would be the Rick Bailey Revocable Trust dated, if I use today, October 21st, 2025. If I was signing it today, that date matters. Now, let's go forward. Let's say a year from now, I decide it's time for me to update my trust. And you can go to the attorney, you can, say, you know what, it's a simple thing I'm going to change. I just want to change, the trustee from John to Bill. I can go in there and say, you know, I would reference the Rick Bailey Trust dated, October 21st, 2025. And I would title this the First Amendment to this trust. And I would say, as trust grantor of this trust, I'm going to, remove section 3.5 and replace it with this language. And there I would say, here's how my new successor trustees are. Sign it, date it, notarize. And that should be sufficient. One thing to be careful of: handwritten amendments to your trust or your will are not valid. If you go in, and I see this a lot of times, people will take their will and or their trust, and they will start going through that with a pen, and it's like, oh, I don't want this. They'll scratch it out. Or they'll start writing in the margins, hey, I don't want this going to Rick. I wanted it to go to Kim. All of those if you're making handwritten remarks on there, not only are those ignored, but in most cases, you've invalidated the whole document. So it's as if that document did not exist. Pull out the state law. That's what we're going to use. Or we get to go to court and fight about the whole thing. So make sure if you're making those amendments that, number one, you know what you're doing, or go ahead and have an attorney, put those together for you. Shouldn't cost a lot, but there again, some attorneys get over anxious on their billing.
Very helpful. Next question. Can you do the right of survivorship with siblings? One who will be the trustee beneficiary, related to bank accounts and IRAs, etc.
Yes. So when you're working with your bank accounts, so your bank accounts, your IRAs, those types of accounts, the beneficiary designation, you can choose anybody. They don't have to be related. They don't have to be family. If you name them as beneficiary, and that's recorded with your bank, or it's recorded with whoever is managing your trust, your IRAs, those types of accounts, those are contracts. So beneficiary designations actually are under contract law. They're not under estate and intestacy laws. So those contracts are binding, and there is no way, after the fact, we can't break those. So here's what I will remind you to do. If you name a sibling or whatever, just remember who they are and revisit those on a regular basis. I have been the bearer of bad news way more times than I've ever wanted to. And I see this especially in a divorce situation. In the divorce, the judge says, here's how we divide the assets. And a lot of times I'll see in there, it will say, half the retirement account goes to him, half the retirement account goes to her. Or it'll say, you get the house, they get the retirement account. And they don't ever change the beneficiary of that account. Well, someone passes, the documents get pulled out, whoever is the named beneficiary gets that money. It does not, it's one, and I've heard this more times than I can count. That's not fair. And I said, fair doesn't come into this now. I cannot control it because contract law says at the date of death, that paid to whoever the named beneficiary is. So I say review those on a regular basis just to make sure it's the right spot, right person. if it's supposed to go in trust, whatever, it's going where it belongs.
Exactly. Your wishes. Next, can you appoint both children? I guess there's two children in this case. Can you appoint both children to be co-executors, or is it really best to just appoint one of them?
Here is my best answer. Who should it be? And it's one where I've had siblings that, where we've had two siblings and they have managed that as co-executors, co-trustees. They've been co-agents on the powers of attorney and get along absolutely perfect. You would, if you've got multiple, if you've got co-trustees or any fiduciaries, you have to make sure there's language in there that says, number one, do they have to act together on every decision, or can they act independently? And I would say it's probably a 50-50 split on the documents I review of which direction they go. If I'm going to name them as co, typically if I'm thinking it through, I'm either doing it out of convenience or I'm doing it out of obligation, or I do think they're the right people for the job. Now, let me give you the word of warning here. If you're doing it because your kids can't get along and you figure, hey, let them work together on this, you know it's going to be a train wreck already. Now everybody else gets to experience the train wreck with you. And it doesn't work out nice. It doesn't work out right. So put the right people in there. I mean, I've had situations that I've looked at from the outside. It's not who I would pick, but I've talked to mom and dad and they said, nope, this is the right person for this job. It's one I've been named previously on one that they'd both been married 3 times. They had between them 13 kids. And they said, we cannot name any one of our kids as the executor. And I was asked because of my relationship to them. I accepted the responsibility, and they made it clear Rick's the fiduciary on this, and if he's not happy, he has the ability to exclude you from everything. So they made it clear, and it worked out great for me. But I do know the family. They could not have named any one of those 13 or any two of those 13 as co and had a good result. So all I say is put the right people in there. It's not a glory position. It's not a position, if you've gone through it, that you will ever say was pleasant. It's frustrating, it's tedious. Um, nobody understands the amount of work going through. So put the right people in. If it's two kids and hey, they get along great, put them in. If not, put them in order or put somebody else in there.
Yeah. Perfect. Next, my question was not how to change a trustee. I was talking about people or organizations that you want to leave money to. You said those kinds of amendments could be made just by having it notarized. So I guess it's a clarifying question.
Okay. So if you're going to change anytime you update your trust or will, if you're changing beneficiaries, so if and I'll take a couple different things here. If you're going to update the beneficiaries, so let's say instead of charity A, you're going to put, take them out and put charity B. There again, the amendment process is the same. And in there, you would say eliminate charity A. Just reference what I would say if you're doing this on your own, reference the document. So the first, trust, this is the First Amendment, section 5, 6, whatever it is, delete XYZ charity and put in ABC charity, sign date, notarize. Make sure it's typed not handwritten. If it's a will, it would be instead, just so you know, amendments to a will are called codicils. And why they can't call them amendments, I don't know, but it's Old English law. They're called codicils. So you would have, codicil 1, 2, 3, whatever. And just in those, you have to have two witnesses and a notary. So just be careful there. Yeah. Now let me take a completely different view here. If it was part of your, let's just say part of your investment account, and you have named beneficiaries on that investment account, you can change those any which way you want, sign them, and just make sure you're following that institution's rules on beneficiary designations.
Great. Next, if no beneficiary is listed for an IRA or 401k and no will or trust, what happens to that account upon the person's decease?
So that one will go, basically, it goes under a state and your state's intestacy laws. So every state has rules that say, here's what we're going to do. So that IRA, if there's no named beneficiary, what the default language is says it will pay to your estate. So they would go through and say, if it was mine, it would say Rick Bailey. They would, it would just, hey, nobody's, there's no named beneficiary. Let's be honest, it's going to sit there in that account until somebody raises a red flag and says, hey, something needs to be done with this money. Typically, somebody will make a claim for that. But now that money technically will roll from the IRA to my estate. Under there, we need the probate's going to happen, and the state intestacy laws will state where that goes. And I can tell you, I see this on a lot of, not as much on IRAs, where I do see this as in like life insurance.
Hmm.
As people will put this in life insurance and say, hey, maybe I'll put my spouse first, then just have it go to the estate. And there again, now it rolls it back into a probate issue versus into your trust or other planning. So just look at, do you have primary beneficiaries if you want? Do you have contingent beneficiaries? And if you have a trust, make the IRA contingent beneficiary go to your trust.
Perfect. Next question. Can you designate in the bank IRA beneficiary doc if the first recipient passes, the funds go to the second heir?
Yes. So you can have primary beneficiary, and you can have a contingent beneficiary.
Hmm.
So it's one of you. In that case, a lot of times I'll see, give it to, primary, let's say, says, give it to my 2 kids. Contingent would be to give it to my 4 grandkids. So you can have primary and secondary beneficiaries on any types of account like that. And just remember, that avoids your estate, your trust and will planning, because it's going to go by contract. So whoever the beneficiary is, they get that. So I'll give you a little warning here. Let's say you put, one of your kids as the primary beneficiary of your IRA, and then in your trust it says divide the estate equally, but maybe give, in that case, your other child a little bit more to offset the IRA. Just remember, the IRA goes separate by contract. It does not coordinate with what's in your trust or will. So if you want extra to go to them, great. If you thought it was going to be balanced, you've got to make sure that you just think that through a little bit.
Exactly. Next question. How do you learn if the state is a community property state? Illinois, North Dakota, or Florida? We may move to one of those soon.
There's only, this off the top of my head, it's been a while. I think there's 11 states that are community property. Um, that's one, Google it or send me a quick note and I'll give you the list. But it's one, I do know the ones out west a lot better than I know the ones on the middle of the country or the East Coast.
Interesting. Interesting. Next question. Can a person who learns he's an executor after someone dies refuse to serve in that capacity? And then what
Absolutely.
happens?
So you do not have to serve if you do not want to. So you can either refuse to take the position or you can resign if you're in that position. And if you do, then it just goes to the next, whoever's next up. If there's nobody named, then it goes to the court to decide. So it's
Right.
one, I always try to, make sure we're thinking this through. I just talked to somebody the other day that was, he's thinking, getting ready to do his planning. And he was thinking, well, should I name my mom? He said, I'm a little concerned. My mom's 79, and I just don't know if she's got the ability to do it. I said, well, if you're asking that question now, the answer is probably no. Because either A, she's, from the way he was talking, I'm assuming she just doesn't have the capability. She probably has the mental capacity. That's not an issue, but just the capability of doing it. And so think through who you're putting in place, make sure they're willing to do that, and that's a list that should be updated more than it is. And it's one I saw, this was with my dad. My dad was a CPA, and I saw multiple clients would name him but never told him. And
Hmm.
then after he retired, he was still being called and saying, so and so named you as the executor. Are you willing to do that? Well, he hadn't talked to him in 10, 15 years. And out of responsibility, he would try and get the best result. But at that point in time, he didn't have the capability to do it, not the way it should be. So just be careful. But if you're named, no, you don't have to serve.
This planning really is an act of love, isn't it? By getting all of these affairs in order, thinking it through, um, it's so important. We have two questions. We're after the top of the hour here. We have two questions remaining. When beneficiaries of trusts are equally four siblings and real estate property, let's see. When beneficiaries of trusts are equally four siblings and real estate property, and one sibling is the executor, do all four beneficiaries have to agree on the decision to sell, rent, keep, etc.?
It depends on what the document itself says. So it can be as simple as, upon passing, the trustee is supposed to distribute out to the four. And if that's the case, then the trustee is going to sign a deed that takes it from mom or dad's name and puts it in, or takes it from the trust name and puts it into the four kids' name. There are situations where it will say, and more where it's, if there's needs for money inside of the estate to pay remaining income taxes or debt, the trustee can sell that property to pay off the debt and other things. And the four do not get a say in it. It's purely the trustee. So it's going to be dictated by how the trust language is set up and what the assets and debts are at the time of passing.
Perfect. And the last question. If you have a will drawn up in one state and now you live in another state, do you have to redo your entire will, power of attorney, and any trust you may have?
Depends on the only big big one I would say is if you're going from a separate property state to community or community to property, or if you're in Louisiana going to any state, then the answer is yes. Um, but I would at least have it looked at to make sure that nothing needs to be updated. Typically, what you would update is like in the trust, it probably says, you know, this trust is based on the state of, a state and managed by the state of Arizona. And then I moved to California. Well, do I want it based on Arizona law or California law? And if I don't update and I die and I'm in the state of California, Arizona law can still apply, which may or may not be a problem. So I would have it looked at just to make sure everything's current. Most of the time, it's either just update the state that it's basing the law on. But as long as it's not a major change from a community to a separate or vice versa, then we're typically not going to have to redo everything. But it's good just to make sure.
Absolutely. My goodness. Well, Rick, thank you for an informative session, and thanks to all who attended today. We hope you found this second session useful. We'll meet again on Tuesday, November 21st, once again at 4 p.m. Pacific. You may have seen a recent mailing entitled "Come Home to What You Love" about our residential program here. We'd love you or a loved one to consider exploring living at Ardenwood and also help us spread the word. As Rick said, I mean, for being here the first time, how beautiful it is here. We have many beautiful rooms. And before we go, let me remind you of a few upcoming events. The first is a Medicare webinar, Medicare for Christian Scientists, this Thursday, 2 days from now. There'll be numerous changes coming in 2026, so be sure to register on our website, ardenwood.org, for this event. And there will, of course, be a replay. The second upcoming event is a talk being given by Christian Science practitioner Mike Muslin of Newport Beach, California, and also a former Ardenwood trustee, on helpful tools to dive deep into the weekly Bible lessons. And finally, we invite you to join our annual Christmas celebration, which is coming up on Sunday, December 7th at 2 p.m. Pacific. Again, you can register for all of these events on our website, ardenwood.org. Rick, thank you, and thank you all again for coming today, and goodbye for now.